are back on the record in the matter of the state of Georgia versus Kianna Davis. We are outside the presence of the jury. We're going to have a charge conference, and the defendant is present with our counsel and the state's counsel. So I'll let Mr. Grooves request a charge sitting in the middle of my desk.
Okay.
They're on the front part of the desk. Okay. Right where I would be sitting.
I have another copy for you.
It's okay. I got 2 copies on my desk, Mr. Grooves. You should be able to hand them to me and I should keep up with them. I just sat them down earlier and then. All right, let me tell you what I've got and then we'll go through each of y'all's requests. And when I refer to what's in the draft I have already created, it is the most recent pattern charge unless I say otherwise. So I have issue and plea of not guilty, presumption of innocence, burden of proof, reasonable doubt, grave suspicion, jury as the judges of law and facts, evidence generally. I have used the short version of direct and circumstantial evidence, credibility of witnesses, expert witness, witness impeached, prior statements, thank you. Immunity, okay, we don't need that one because the co-defendant did not testify.
We agree, Your Honor.
Take that out. I have single witness corroboration, defendant's choice not to testify can come out.
And also you had accomplice corroboration, that comes out.
Yeah, and okay, so I have, before we get to that one, I have the statement of the defendant. And I did not put all of the Miranda stuff in there. But I did leave, initially, hold on a second, I'm trying to, yes. I left the draft open on my desk. Okay. So the pattern statement of a defendant says, a statement that the defendant allegedly, and it says, made while in custody has been offered for your consideration. So determine whether the defendant's statement was voluntary, and if the statement was in custody, whether the defendant was properly advised of her constitutional rights. Well, that's, I mean, either, you know what I'm saying? I don't know why it's phrased that way. Because my intention had been at first to give statement of the defendant 1.32.16 and voluntariness 1.32.17 and not the rest of that about Miranda and all that, because we all agree these are not custodial interrogations. Or whether or not we all agree to that, that is what the evidence is and what the court has found. So I guess my first question is, do I give it at all? Is it appropriate to give those 2 paragraphs? And if so, then I'm going to read a statement that the defendant allegedly made has been offered for your consideration and take out the while in custody and then just leave those 2 paragraphs otherwise as written.
That's fine, Your Honor.
Because voluntariness is always an issue, even when Miranda in custody is not.
The new version appears to have the while in custody in parentheses.
Okay. Maybe that's just it. When I cut and pasted, I didn't. Okay. So, see, the pattern is going to do what I said we should do anyway. So, yay me. Okay. So we will leave that a statement that the defendant allegedly made has been offered for your consideration before you consider blah, blah, blah. Okay, that one's good. Let me take out I had highlighted some stuff that I know we would need to discuss. So that comes out, and then voluntariness. Then I have, and I think in the version I printed for you, all the accomplice stuff was in there. I took that all out. Okay, so then I have definition of a crime, intent, no presumption, criminal intent, parties to a crime, principal, failure to prosecute, knowledge, mere presence, mere association. I added, and I can't remember if I did this after I gave you a printed copy or not, I added statute of limitations. So it reads, and I had to do a little, the statute obviously is different for murder than it is for the underlying felonies. So it reads like this. Members of the jury, the law of our state sets a time limit upon the state in starting prosecution of most criminal offenses. The accused is on trial for the offenses of murder, aggravated assault, cruelty to children in the first degree, and cruelty to children in the second degree. Under Georgia law, there is no statute of limitations for murder. However, prosecution for the offenses of ag assault, cruelty to children in the first, and cruelty to children in the second must begin within 4 years after the offense has been committed. If you find from the evidence that the indictment in this case was not filed within 4 years after the offense was committed, it would be your duty to acquit this defendant.
That's fine.
All right, then I have venue generally. I also added some language to the venue charge because the testimony is that the official declaration of death occurred in Peach County. So there is some, and this comes out of the pattern. So it says the law provides criminal action shall be tried in the county in which the crime was committed. Venue that the crime was committed in Houston County is a jurisdictional fact, must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment just as any element of the offense. Venue must be proved by direct or circumstantial evidence or both. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. Because I suspect otherwise we may get a question on that, and rather than, I need to be clear about that. Okay. Malice murder is the pattern. I have the paragraph on the state does not prove premeditation. Malice is how long or how briefly the malicious intent, no specific time, so on and so forth. Motive, you don't have to prove motive. Then felony murder, and here's the way I did this. It says, for felony murder, the state must prove the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Then I said, count 2 charges felony murder with cruelty to children in the first degree as the underlying felony. Cruelty to children in the first degree is a felony, which I will define for you now. Then, for cruelty to children in the first degree, the state must prove the defendant maliciously caused. And let me adjust to the indictment. It's cruel physical, isn't that the way it's alleged?
Yes.
Okay, so cause cruel physical pain to a child under the age of 18 years. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the pain without justification or excuse, willfully doing an act while aware of strong likelihood the pain may result. That's all pattern. Then I went on to say, count 4 charges felony murder with aggravated assault as the underlying felony. Aggravated assault is a felony which I will define for you now. For aggravated assault, state must prove that the defendant, and in this adjusted for the evidence, assaulted another person with an offensive weapon. Then an offensive weapon is any object that is likely to or actually does cause death or serious bodily injury if used against someone. In deciding whether the unknown object is an offensive weapon, you may consider all of the following factors. And again, this is pattern. Nature and extent of injury inflicted, character or capabilities of the weapon, manner in which it was used, any display of it to the jury, and any other circumstances in this case. Then murder in the second degree. Statements prove that the defendant caused the death of another person by committing cruelty to children in the second degree. State does not have to show malice. Define cruelty in the second degree for you shortly. Cruelty. I'm not going to do it shortly. I'm going to do it right now. Hold on. I will define cruelty in the second degree. For cruelty to children in the second degree, statements prove the defendant caused, is it cruel pain again or excessive? Cruel physical pain. Caused cruel physical pain to a child under the age of 18 for criminal negligence.
I think you also have to define criminal negligence.
All right, and then I have verdict, which is a pattern. Court has no interest, sympathy, sentencing is the court's responsibility, deliberations, unanimous verdict, retire to the jury room, alternates go over there. Okay, let me go back and look at the malice too.
Criminal negligence is 14140.
Interesting, it's not.
Right after cruelty in the second degree.
Right. That's going to be the most common way that would be charged, but I'll make a note for the pattern jury committee. I'm sure they'll be thrilled. All right. I agree that that needs to be charged. Criminal negligence is an act or failure to act. In this case, it's charged as a failure to act, I think. Okay, so criminal negligence is a failure to act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably expect to be injured by the failure to act. Okay. Does the state have other charges that I have failed to include that you believe are necessary or appropriate?
No, Your Honor.
All right, let me go through. Mr. Groove has properly submitted his request to charge. I think we've got most if not all of them, but I'm gonna go through them. I'm gonna give and when I say I'm gonna give it, I'm giving the most recent pattern. I'm not matching word to word Mr. Grooves, but I presume they are the same or, so I'm gonna give one, I'm gonna give two, I'm gonna give three. I do not think, all right, you want four, Mr. Grooves?
Yes, ma'am.
Where is that? See. I know that's a pattern. Can somebody tell me where it came from, which section it's in, if I can't find it? Did we get rid of it somewhere?
Judge, I don't think so, and I've been asking it since the beginning of time.
Right, I know, and there, it comes straight from a pattern. I'm honestly I'd like to cut and paste, and I can't find it. So I want to make sure we didn't eliminate it for a legal reason.
I think years ago it came from that case, Sandstrom versus Montana.
Right.
I think it's 141.12, Judge. Presumptions and inferences.
Well, I called myself. Yeah, see, you guys are working on an old book.
We are?
Hold on. Oh, there it is. You're right. Y'all are correct. There it is. Okay. Okay, I'm going to put it after, no, where it comes in the pattern, right after no presumption of criminal intent.
John.
Give me just a second, y'all, because I'm cutting and pasting as we go, so I have it all in front of me when we get ready to start back. Okay, so we'll give 4. I'm going to give 5, which is grave suspicion. 6 is evidence. 7. The testimony of a single witness. Right, some of 7 is the accomplice. And we don't have any of that.
I have no problem with that coming out.
Okay, so I am going to give the first part, which is the testimony of the single witness. So I'll give the single witness portion of 7, but not the accomplice portion.
Yes, ma'am.
So that's the 2 sections. I am going to give 8. I'm giving 9, or the current version of that.
Yes, ma'am.
10, expert witness. I'm giving mere association. That's 11. I'm giving credibility of witnesses. And that, what Mr. Group has as 12 is credibility of witnesses, impeachment, and credibility. And so I'm giving all of those. 13 is not, I'm not going to give 13 because there's no as Ms. Davis chose to testify. I am given venue with that extra homicide section that I said, which is 15. All right, accident. Mr. Dwayne, what is your position on accident?
Well, I think the testimony of both medical examiners is that this wasn't an accident. I don't think there's any evidence that anybody said observed that he fall. I do think, despite her denials when she testified, there are witnesses who stated the defendant told me she fell. So, I guess in that context, it might be applicable.
All right, well, a jury could disregard or not believe the evidence of the medical exam.
Right.
And there has been very little, it's not like there was a specific accident to which this injury is being attributed, but there have been discussions about that. So I'm going to give it, I think that's cleaner.
Thank you, Your Honor.
I gotta figure out where it goes. I think it goes after criminal negligence and before verdict.
Yes, ma'am.
Do you have the number for it?
It's 3.50.10. And this is what the current pattern said, which is a little different. An accident is an event that occurs without the defendant planning, expecting, or anticipating it. You may not find the defendant guilty of a crime if the alleged criminal act was committed by accident and there was no scheme, intent, or criminal negligence by the defendant. And then it defines criminal negligence, and then if the defendant raises the defense of accident, the state has the burden to disprove it beyond a reasonable doubt. All right, and then, 17 is knowledge that goes with parties of the crime, that's in there. 18 is murder, which is in there. 19 is murder of the second, which is in there, and 20, and we've talked about the patterns there. So I think that's everything. Mr. Groove, anything else, based on the way the evidence has fallen out, that you would like the court to consider or charge on?
No, ma'am.
Mr. Dwayne?
No, Your Honor.
Okay. Do you guys want a new copy of what
Please.
I'm actually saying, or are you good?
Please.
All right. Now, I will tell you, I can't swear there's not a typo in here somewhere, because I'm cutting and pasting it as we go, but do we put paper in there? Let's see if that works. Mr. Davis, is Lisa in there today?
Ma'am?
Is Lisa in there?
No. I can go check. She was also.
Ask Annie if he filed it. Tell us. Thank you. Okay, exhibits. Everything's going out but the videos. Yes?
Yes, ma'am.
Okay.
Yes.
And then if they want to watch something again, they can ask for that here too. Okay, anything else before we bring the jury in for closing arguments?
No, Your Honor. No.
All right, I just sent Bob to do something else, so it's not you blame in the jury, please. Oh. We needed an indictment. I guess we can send this one out, they know he's charged. Hold on 1 second.
In a verdict form, do we have a verdict form?
Yeah, I'll print the verdict form. I didn't, but I'll print it.
I don't have any problem with that.
Okay, does anybody care that both names are on it, or is there any reason?
No, and
All right.
it's nothing been signed or anything, I don't guess.
No, it's
Been
just the
clear
not
on trial.
guilties by both of them.
Yeah, I mean, I'll try and,
Actually, this one does not even have Mr., this copy does not have Mr. Benton's not guilty. Because his not guilty is in his file. But I will probably take that page out and put his not, so they both have entered their not guilties on that document. Okay. Now you can bring them in.